We still have people joining, but I think we're going to begin because we do have a full program for you today. I am Elisa Scally. I am a partner with Gowling WLG, practicing in the Employment, Labor and Equalities Group, ELE for short, because that is a mouthful. I'm very excited to welcome you here today to the first webinar that is being presented as part of our webinar series in 2022. We're kicking off our webinar series with a very hot topic, and that is the new requirement under the Employment Standards Act to implement a disconnecting from work policy. We have had many questions from employers regarding this new requirement, and we are here today to break it down for you as best that we can. To help us do that today, we have Bettina Burgess and Hina Gauss with us. Bettina and Hina both practice exclusively in the area of employment law, and they work out of our Waterloo office. Bettina is passionate about employment law, but her true love is for her two Bichon Shih Tzus. Her kids realize that she loves her dogs more than she loves them when they realized that she'd started using the dogs' names as her passwords rather than her kids' names. And I have to say, sadly, my kids realized the same thing when they noticed I replaced their photo on my screensaver with our dog's photo. Hina is not only a talented artist, our lawyer, but she's also a talented artist, I learned. She won an art contest many years ago for creating a sculpture of the human brain. We will also have the benefit today of the insight of a distinguished panel of employment lawyers coming from France, Ireland, and Italy, where legislation regarding disconnecting from the workplace is already in place in those jurisdictions. Our panel will be joining us a little later on in the webinar, and we'll introduce you to them at that time. And we're really looking forward to hearing their insights on how they've implemented the disconnecting from work policies and practices. So before we get started, just a few notes to mention. We will not be doing a live Q&A at the end of the webinar today, but the Q&A feature will be open. So please add your questions to the Q&A. We may answer some of those questions during the session, but what we hope to do is collect the questions and provide answers to you following today's session, whether that be in writing or by way of a follow-up recorded session. And to note, today's session is being recorded, and the recording will be made available to you after the session today, as will the PowerPoint presentation that you will be viewing today. So let's get started. I'd like to now turn it over to Bettina. Bettina, you're on mute.
Sorry about that. We were talking yesterday as we were rehearsing for this, and Stephen, one of our BD fellows, was talking about a t-shirt that he saw that says, "You're still on mute." I clearly need that. Well, welcome everyone. I don't know what it's like in the regions where you are, but it has turned out to be a really awful day here in PW with rain, freezing rain, and school buses are closed or down. Schools are closed. So hopefully you're tucked away in jammies somewhere watching this webinar. So there's been a lot of hype since this legislation came into force first was put on the table back in October and then came into force in December. And we all scrambled a little bit to figure out what's going to happen and what's going on. So hopefully today we'll give you some guidance. We plan on going through all of the strict legislative requirements that we know of to date. And then about an hour into the presentation, we're going to bring on some panelists from Europe, Italy, Portugal, and Ireland, who have already dealt with this legislation in their jurisdictions, and we're hoping to get some practical advice from them about how their clients have dealt with very similar legislation. So to begin, as everyone knows, there's a new requirement under the Employment Standards Act, specifically Section 21, requiring employers who have 25 or more employees in Ontario to develop a policy dealing with the right to disconnect. Next slide, please. And there are lots of reasons why this may have come about. Interestingly, the concept of the right to disconnect has its genesis in France, we think, in any event, back in the early 2000s, there was a case that went to court in France where an employee was, the employee's employment was terminated for failing to respond to his manager's communications after hours, and he was terminated for misconduct. And in that particular case, the court held that it was not misconduct warranting termination of employment, that the employee did not respond to communications after working hours. And that led to, over time, of course, the evolution of right to disconnect legislation, at least in Europe, in after 2010, and we'll hear from the other European colleagues about that legislation in a little while. So the cynical view, of course, is that the Conservative government in Ontario is trying to win some political points with workers so that they can be reelected. There are lots of things that I'm sure that you've noticed that Doug Ford is doing to make things better for workers, we hope, but a little bit more challenging for employers. Giving everyone the benefit of the doubt, the rationale that the government has indicated during the legislative debates and so on is to really deal with mental health and burnout that so many people are now experiencing, have been for so long in this very fast-paced environment in North America, and of course with the advance of technology, and then in particular with COVID, everyone working from home in front of their laptops, no way to break up the day. And so this was perhaps a response to that. And then, as I indicated, the practical view with the advancement of many different forms of technology that results in the expectation that you're going to respond instantly 24 hours a day. Sometimes this sort of patriarchal approach to changing culture is necessary. So legislators decided to codify certain elements that we want to see changed in society. Next slide, please. Okay, so let's get into the meat of it. To which employers does this legislation apply? It does not apply to federally regulated employers at all. So if you're in banking, telecommunications, shipping, aeronautics, industries like that, you don't have to worry about it. It doesn't apply to every single provincially regulated employer in Ontario. It applies in all industries. I did a webinar last week and I was asked, well, does it apply to farmers? Yes, it applies to farmers if they have 25 or more employees. It applies to businesses that are, or organizations that are for-profit, not-for-profit, charitable, sole proprietors, corporations. It doesn't matter what type of business you have. If you have 25 or more employees, you're provincially regulated, and you carry on business in Ontario, then you have to have this policy. Next slide, please.
So if you're a provincially regulated employer and you have 25 or more employees, then you meet the threshold for having to have this sort of policy in place. But the question really is, when are employees counted to determine if you need to have this policy in place? So the trigger is actually January 1st of each year. So whether a policy is required from year to year could change, but the seminal date would be January 1st. So for example, if you are a provincially regulated employer and you had 25 or more employees as of January 1st of 2022, then you're caught by this new requirement, and you do need to have a disconnecting from work policy in place. For this first year that the legislation has been introduced, you have to have the policy in place by June 2nd, but going forward, it's by March 1st of each year. So say you had 25 or more employees this past January 1st, then you need to have a disconnecting from work policy. This is even if the next day on January 2nd, your employee count dropped to under 25. On that seminal date, you still met that threshold, so you need to have a policy in place. Then the next count of your employees would be the subsequent January 1st, so January 1st, 2023. And then if you meet the requirement or not, if you meet the requirement of 25 or more employees, then you have to have a policy in place by March 1st of 2023. And then March 1st is the date you need to have that policy in place going forward. Next slide, please. So in terms of who's included in this count, the policy requirement really applies to all employees. There are no exceptions other than Crown employees. So all employees really means whether you're a probationary employee, a part-time employee, full-time, casual, fixed term, whether you're working remotely, if you're on a leave of absence. All of those different employees that an employer has are counted in that 25 or more threshold. If you're an employer that has multiple locations across Ontario, then the employee count is actually collective from all of those locations. So all employees really does mean all employees. But that also means that it does not apply to independent contractors, provided that independent contractors are classified properly.
Okay. Ongoing with who is included in the count. Oftentimes, of course, employers use temporary or assignment employees as they're defined under the Employment Standards Act. So you engage someone through an agency, but they're working in your organization. And the question becomes, do you have to count those individuals? And the answer is no. They would not be included in your count. They would, however, be included in the agency's count. So if you are a temporary or assignment agency, you have to count all of your employees as of January 1st, whether they're presently engaged with another client or not engaged, but still employed by you. So in other words, they're waiting for their next assignment, but they're not technically active at that moment. They still must be included in the count. And the other thing to keep in mind, although this doesn't happen terribly often, there could be situations where two different entities could be held by a court to be related, or a tribunal to be related or common employers. In those situations, a tribunal might find that you have to combine your employees, and therefore both entities ought to have had a right to disconnect policy. That's likely going to be a rare situation, but just something to keep in mind. If you have an entity where two different entities that you sort of partner with and you share employees back and forth, you could have to count the totality of both entities. Next slide, please.
So say you're a provincially regulated employer and you meet this employee threshold count, then the next question is, when must this policy be completed and when do you have to provide it to your employees? So there is a special rule, as I mentioned earlier, for this first year that this requirement is being introduced. So for 2022, if you meet all the requirements, the policy has to be in place by June 2nd, 2022. Then going forward, the policy must be in place by March 1st of each year. Now, in terms of the logistics of what the policy involves, the legislation does speak to this, even though it covers almost nothing about what the policy actually should include itself. So in terms of the logistics, the policy has to indicate when it was prepared. So you want to have that right there in the policy, as well as the date of any changes that may have been made. So in terms of when the policy has to be provided to employees, there's basically 3 different time periods that you want to keep in mind. So you have to provide a copy of the policy to all employees within 30 days of when you first prepare the policy. Then, if you make any changes to the policy, you need to have a copy to all employees within 30 days of any changes that you made to it. And then going forward, whenever you hire a new employee, you need to provide them with a copy of the policy within 30 days of that employee being hired. Now, that being said, if your policy hasn't changed from the year before or 2 years ago when we're in the future, you don't have to provide a new version, a new copy to each employee if there have been no changes, unless the employee is a new employee. And then lastly, there is also a requirement on how long you want to maintain the policy. And the legislation says that you want to maintain it for 3 years after the date that it is no longer in effect. So you do want to keep copies, if you have any sort of audits, to have that controlled. So next slide, please. So now that we know you have to provide a copy of the policy to all employees, the question is, does it have to be in any particular format? And the answer is no. It could be a print copy, but you can also just provide it through an attachment to an email. You can send it through a link online. The employment standards guidelines really say that as long as the employee has a reasonable opportunity to access the policy and print it if they want to, that's okay. Now, I don't know that many employees that are going around printing policies nowadays, especially with our paper-free offices, but that's the thing. As long as they have that opportunity, that's good enough. And then lastly, the policy does not have to be a standalone policy. This can be included as part of any employee handbook or manual that you already have. You can just put it in there and meet your basic requirements for having the policy. Next slide, please.
Okay, so what does the legislation actually say with respect to what disconnecting from work means? So the specific text in the legislation says that it means not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or reviewing of other messages so as to be free from the performance of work. So the definition makes clear that the intent of the legislation is to ensure that the employee is not performing any work during a particular period of time. Now, later on, we'll get into what the actual specific requirements are under the legislation, which is actually none. But as you're considering drafting the policy, think about things like this. When we all think, because of technology now, that, oh, I'm just going to send this email or I'm just going to send this text message and the person will just read it. They don't have to respond to it. It's only going to take them 2 seconds to review and respond. But that's not really true, because if you think about the times that you get an email or a text message with respect to work, yes, it might only take you 2 seconds to respond to it or 2 minutes, but you might be thinking about it for 10 minutes, 2 hours. I was telling everybody last night that I woke up and at around 1 o'clock in the morning and should not have, but did look at my phone, saw a message from someone, and I knew I was not going to be able to get back to sleep. So I got up at around 1:30 and responded to the email. And so this is one of the reasons that we believe that this legislation has been enacted, so that employers start thinking about the psychology of sending these messages after hours and what it does to an employee. And we'll get into a little bit more of that as we go along. The legislation goes on to say a written policy required under this legislation shall contain such information as may be prescribed. And this is what I was alluding to, that there is no prescribed information yet set out in the legislation or regulations. When we looked at the legislative notes while the bill was running through Parliament, the intent indicated by the legislators is that they intentionally left it blank with no specific requirements as to what needed to go into the policy in order to allow flexibility for various workplaces. They're putting trust and faith in the employers that they're going to be thoughtful about what they put into the policy and take into consideration the needs of their workforce without having to prescribe it. The cynical view could also be they really wanted to get this legislation put through very quickly and didn't have time to actually think about it. And so we may see some regulations coming out in the next little while, in the next year, however long, as this progresses. Next slide, please. Okay. So oddly enough, and we've now, for a while, we just had the legislation, but the Employment Standards Branch has now issued guidance. So if you go to the Ontario Ministry of Labour website, you can look, there's now a page where the Employment Standards Branch has given a little bit more information as to how this legislation might be interpreted. What is set out there is that the legislation doesn't even provide employees with a right to disconnect other than what is already in the Employment Standards Act. And we'll go through what's already there that protects employees with respect to hours of work restrictions and the right to be free from work at various times. And so this policy could conceivably be, nothing. It could essentially be a paragraph and you would be in compliance because there is no requirement to establish new rights. But we'll talk about later in the presentation how that could potentially be dangerous for an employer if they take this just by the strict letter of the law and not comply with the spirit of the law. Next slide, please.
So Bettina read to you the definition of disconnecting from work that's in the legislation. The definition gives you examples of what work-related communications are. It uses the word includes, which means it's a non-exhaustive list. They're really just examples. So the legislation says it includes emails, telephone calls, video calls, and the sending or reviewing of other messages. But the term work-related communications is really flexible enough to cover, various types of technology. It's also flexible enough to cover any form of communication you can really think of. So for example, iMessages, Slack, any apps developed in-house, Hogwarts Owl Post, all of that could fall under the definition of work-related communications. So really be mindful of the types of things you want covered in your policy and how they're going to be used going forward. Next slide,
Thank you, Hina. I made her say that stuff about Harry Potter. Thank you. Okay. Developing the policy. So here's where we get away from the strict letter of the law and we start thinking about what are the potential practical implications of the legislation. So the legislation does say that employers have to have a policy that addresses all employees. As Hina noted before, there are no exemptions at all. We think that this might have been an oversight and eventually the regulations may say that individuals such as managers, supervisors, commission salespeople, various professionals and so on are exempt from this requirement, but right now it's everyone. So you have to be very careful about how you draft the policy so that you're not accidentally including, applying it to certain positions that you don't want to. And we'll talk about that a little bit later. And I should note, because we have, even though I've said that in other presentations, we've been asked the question, so does that mean it applies to CEOs? Yes. So far, it applies from everyone from, receptionist, low-level administration, all the way up to CEO, president, COO, and so on. It will be considered a violation of the ESA if the policy attempts to carve out certain positions and say that this doesn't apply to you. You can have different terms that apply to different positions, but you can't say, this only applies to X employee, group of employees or class of employees. It must apply to all. Any term that's included in the policy if it is deemed to be a greater right or benefit, will be enforceable under the Employment Standards Act as though it's a statutory right. So in other words, and Hina is going to go over the different rights that already exist, but if you have in the policy that non-exempt employees will not be required to answer messages or email communications after 8 p.m. And if they do, they will be paid, you know, a premium pay. That is then going to be considered a greater right or benefit because that's not something that they're already entitled to under the ESA. And they can then go to the Ministry of Labor and make a complaint that they're not getting that pursuant to the policy, and the Ministry of Labor will enforce it as though it's a statutory right. The other consideration is that anything that you put in a policy that offers any type of benefit to an employee will likely be deemed at common law to be a contractual right. Next slide, please.
So as Bettina mentioned, this new legislative requirement, if you just do bare minimal compliance, does not actually create any new rights for employees. Now, that being said, there are a lot of existing rights that are already in the Employment Standards Act for employees. I won't go through each one in detail, but these next two slides do cover that. There's things like daily hours of work limits, you know, working 8 hours a day or the regular work day in your workplace, unless there's some sort of an electronic or written agreement where the employee can agree to work a certain higher number of hours than that. So there's things like that that exist. There's daily hours free from work. Employees are supposed to get 11 consecutive hours free from work. There's free time off between shifts. You know, if you have successive shifts versus split shifts, there's these different rules under the Employment Standards Act. A lot of these rules you can sort of contract around. You can have an electronic or written agreement, for example, for weekly hours limits, but as well as for, there's also rules around weekly hours free from work. So all of these are summarized in these next two slides, and I won't go through this in detail, but you want to keep those periods in mind when you're looking at your disconnecting from work policy. So next slide, please. So these existing employee rights, there's also things like meal periods where you're supposed to give employees 30 consecutive minutes every 5 hours. And then the employee can also agree to break up this 30 minutes into 2 15-minute periods. Then there's rules around public holidays, you know, vacation time, and then leaves of absence. So all of these really are existing employee rights that you want to make sure mesh with any disconnecting from work policy you create, especially if you're creating one that's more robust than the minimum statutory requirements. Next slide, please. So in terms of what happens if you have a disconnecting from work policy and you don't really comply with it. So there is that general offense provision in the Employment Standards Act, where if you don't comply with a provision of the Employment Standards Act, you can be ordered to comply, and you could also be fined. So both of those are possible if you don't have a disconnecting from work policy when you're supposed to, when you meet those threshold requirements. But in terms of what kind of claims employees can bring, this is a little bit less clear at this point. Say you have a disconnecting from work policy as an employer, and this policy creates no new rights for the employee. That means really no enforcement action can be taken by someone like an employment standards officer relating to this requirement to have a written policy. You have the policy, and that's what the legislation requires. But if the employer is not following the policy, and then there's other consequences related to that, then there might be a place for a compensatory claim. So say, for example, you have a disconnecting from work policy and the employee's getting messages, you know, all hours of the workday. The employee complains about these messages, and in response, they might have a negative performance review. They might be disciplined. That's a negative consequence, and the employee might be able to claim reprisal as a result of the employer not following their own disconnecting from work policy. And in that sort of circumstance, an employee could make a compensatory claim for violation of this policy and reprisal.
Sorry, I'm just going to jump in, Hannah, because I think you meant to say that if the employee is receiving communications beyond the normal workday rather than through the workday. So for example, if you have a manager who just refuses to comply with the policy that the employer has implemented and continues to text and email his or her team after, during restricted periods pursuant to the policy, and then gives the employee a bad review, similar to that case that we talked about in France. Then the employee, or, if the performance review ultimately results in the employee being terminated, there could potentially be a reprisal claim, which could result in compensatory damages. Thank you. Okay, moving on, next slide, please. Okay. So what are some of the other things that we have to consider that may arise as a result of having this legislation just outside of the ESA? Well, if we think about various types of investigations that can occur, or other areas where employees can bring claims, for example, under the Occupational Health and Safety Act, you can imagine an employee going to the Ministry of Labor, talking about unsafe work conditions, they're being asked to work too long, that type of thing. One of the things that an inspector may be looking for now, instead of just your health and safety policy, is what does your right to disconnect policy look like? What's in there? Now, they may not give much guidance as to what you ought to put in there. They may give you a compliance order that you've got to update it in certain ways or have one. But that's another area where it might bleed into outside of the employment standards sphere. We might also start to see more and more work refusals under the Occupational Health and Safety Act as a result of this legislation, because people are going to start thinking about work a little bit differently. One of the things that we'll talk about in terms of what you need to think about when you develop the policy is what are your employees going to be expecting of you now that this legislation is out? Regardless of what your strict legal requirements are, what are they going to expect? And how are they now going to perceive the workplace now that legislators are thinking about the right to disconnect? And is this really a healthy work environment if you're sending messages throughout the night and requiring employees to respond to them or on the weekends? The other area could be constructive dismissal claims. So this could be another way that employees could start to examine the work environment. It's a very unhealthy work environment. And so your right to disconnect policies may become part of court litigation. And then again, just going back to the comment that I made before about internal employee relations issues. We may have a real disconnect between this announcement and sort of this media frenzy that this legislation has come out, and it's in the news that there's this new right to disconnect requirement. Employees may think that you do have an obligation to establish policies that absolutely say you don't have to respond to emails between such and such hours in the day, even though you don't have that obligation as an employer. But your employees may think that you do. And if you turn around and say to them, well, this isn't our strict legal requirement, we're not going to do that, then you might have employee relations issues. And so you have to think about the expectations of your employees, the morale, is this going to be another element that leads to people thinking about unionization, that type of thing. And then, of course, external reputational harm. So are we going to start seeing businesses being slammed in the media because they don't have really robust right to disconnect policies? Are employees going to start posting things on Glassdoor saying, you know, this employer has a 1-paragraph right to disconnect policy? Is it going to be something that employees start to think about when they're looking for work-life balance and which employer to accept employment from? You know, you can compare it to, you know, a few years ago when the big trend was employers starting to get on the bandwagon with top-ups for maternity and parental leave. Well, it's not a requirement, but that sure became something that employees were looking for from their employers. So just something to think about as you discuss with your businesses, how robust is our policy going to be? Next slide, please. Okay, and one of my other colleagues did a presentation on this, and I liked her saying that policies are just pieces of paper that are meaningless unless you train everyone on them, you monitor them to ensure that they're being complied with, and you enforce them and make sure that they're being implemented consistently. So one of the things that is going to be really key after you develop, well, and during the process, and we'll go through that as well, after you develop the policy, to do training. It's not a requirement under the legislation that you do training, but it's certainly a recommendation that you start with the managers, because once the policy is developed, this is definitely going to be sort of a top-down lead by example type of situation. And if you don't have managers complying and they're continuing to email and communicate with employees when they ought not to be, you're going to have some problems. Very standard sort of in performance management type training that ought to be given to managers. And then again, it's really important to educate the employees on what the policy means so that they don't get this sense that, okay, when I go home at 5 o'clock or I log off at 6 o'clock, that means that I never have to look at my phone or my computer or respond to anything for the next 12 or 13 hours. If there is an expectation that they do so in certain circumstances, you need to explain that to the policy or to the employees. This is going to be one of those situations where just putting the policy in front of everyone's face and asking them to read it might not be sufficient. There may need to be an explanation of the rationale and why you developed certain terms for certain types of positions and so on. Again, for the HR folks that we've got on the call, really monitor what your managers are doing, because if they're not enforcing the policy, of course, themselves, if they're not complying with the policy, this could result in liability for the organization. Then again, enforce it. You've got to come down on the people, not necessarily harshly, but you've got to deal with the people who are not complying with it to avoid liability. And then where necessary, every once in a while, retrain, as Hina indicated. If there are changes made to the policy, you might want to have little sessions with employees and managers as to why things have changed. Next slide, please.
Now to get into what to consider when you're really developing the policy, the first step is to just learn about the basic legislative requirements. And the fact that you're all here today, you're already doing that first step, so congratulations. But after that first step, what you want to do is assess what your company or organization truly wants to achieve. So as we discussed earlier, the basic requirements in the legislation are not that onerous for employers. So if you want to proceed with a policy that just meets the bare minimum compliance, you can do that. You would say things like the fact that the policy applies to all employees, You just cover off all the basics about, when you have to post it, what it's gotta, when you have to update it, that kind of stuff. And you would just say that, the company complies with all of the other employment standards requirements, the other things we discussed, the meal periods, all of those kinds of breaks. And then you'd have a caveat that people still have to complete the basic duties that they have to do for their position. So the language on the slide is not something that we represent will meet all of the basic compliance requirements, but it's an example of what a bare minimum compliance would contain. So if that's the approach you're going to take, that's one way to go forward. What this might do is it might just maintain the status quo in your workplace as it is. If you have the kind of workplace where everyone is always working all the time, and then you introduce a bare minimum compliance policy, it's not likely to change much in terms of how employees, how many breaks they take, that kind of stuff. But an issue with having a bare minimum compliance policy, as Bettina mentioned, is morale and employee retention. If other employers are creating much more employee-friendly policies, people have, an absolute right to disconnect between certain hours, that might create an internal employee relations problem and, even talks of unionization in some situations. So if you determine that a bare minimum compliance policy isn't really what's going to work for your organization, then you want to look at having a more meaningful policy. The aim of having a more meaningful policy is really to ensure that employees can take that time they need, take meaningful time off of work. The breaks that they have during the workday are rejuvenating breaks. So to make this sort of a meaningful policy more practical for employers, it takes a little bit more work on the front end. So for example, usually you don't have a one-size-fits-all policy if you're looking for a more meaningful disconnecting from work policy. You might have to split it up by different departments, by different positions to really make it work in the workplace. And then additional things you would have to consider if you're having this sort of a meaningful policy is whether you need to do anything differently in terms of maybe you need to hire more employees. Maybe you need to have some sort of on-call positions available so that you can have a meaningful policy that you can follow and that you can enforce. So next slide, please. So once you've figured out the needs of the company, you've already connected with the executives, the next step really would be to talk to the people. So to connect with the managers, the supervisors, the project managers. This is a really good way to figure out the needs of the organization on the ground. This way, whatever policy you develop is not just going to be a piece of paper. It's going to be something that, that can be followed, where there's input from workers. There might be more of a commitment to comply with it. Sometimes there's more of a sense of ownership when people are involved in the making of the policy. So the types of questions you might want to explore with your managers, your project managers, are, what are the needs of the business? Are there set times where employees really don't need to be reviewing any messages? Are there set times where employees need to be reviewing messages, but they don't need to be responding to them? So if you go back to the definition of disconnecting from work, I thought it was interesting that they split up the fact that they say the sending or reviewing their messages to really kind of mention it's not necessarily the same thing. You can review a message and think about it for the next 2 hours, as I know I've done in the past. So yeah. And then in terms of disconnecting from work policies, most will include something about what to do during emergencies. So things like there might be exceptional circumstances where the employee needs to be reviewing certain messages, maybe ones that are marked urgent. You want to figure out what sorts of circumstances apply in your business. What is considered urgent for your workplace? And then again, if you're looking at having a policy where you want to have the majority of employees being able to disconnect at certain time periods, but you keep having these needs and they're not necessarily urgent, that's when you want to consider potentially having different structures, having more staff, maybe having on-call positions. Like I said, this takes a little bit more work on the front end if you're looking to have a meaningful policy, but it does create a really good overall picture of what your business needs. Next slide.
Okay, so as we've been discussing throughout, although the policy has to apply to all employees and all positions, not all positions have to be treated the same. And so you can have different expectations applicable with respect to different positions. As we were discussing, you can have some where you can think about different periods of the day or the week or the year where you can have a 100% absolute blackout period. You could, if you can fit that into certain positions or policies. Again, these are all ideas to start thinking about. So are there any positions within your organization where you can say you under no circumstances are you to receive, well, you can't help it if you receive it, but under no circumstances are employees to be sent or expected to respond to any form of communication during meal breaks, public holidays, vacation. Those are kind of low-hanging time periods. Or are there certain periods during the day, for example, from 6 p.m. to 8 a.m. On a Saturday or a Sunday, things like that? Then you can think, is there a next level where we have a different sort of level of blackout, meaning you don't have to respond to communications unless you get, urgent, or that's an overused term, but as an employer, there you go. Try to think of a different term. Please respond, must respond, that type of thing. But the idea is start thinking about different positions and really what do we absolutely have to have this employee or this class of employee do during these periods, and are there any periods where we can just give them a break and say you don't have to work or communicate at all. Next slide, please. Okay, again, just further ways to think about it. Are there different types of messages or different individuals that an employee has to respond to? So during certain periods of time, can you tell the employees or have a policy that says during these particular periods of time, you don't have to respond to your other coworkers or management, but we still require you to respond to emails from customers, or you don't have to respond to communications from vendors, suppliers, but we still expect you to respond to communications from management, not coworkers. Now that's getting, you might have a policy that's 20 pages long if you start implementing all of these ideas. But again, they're just ways for you to start thinking about what can we do with this policy. Talk to your business leaders about these different things. So again, who will the employee be receiving messages from? Do they have to respond to those individuals? Next slide, please.
Another way to approach this is to look at whether there's different subject matters that can be part of a blackout period. So what you could do is you can have communications, like all communications don't need to be reviewed or responded after a certain time, or you can make that distinction where, things that are administrative matters like expense reimbursement, billing, all of that doesn't have to be responded to or reviewed right away. There's communications during a blackout period that you could even say don't have to be addressed right away, except the following. And you can list the types of communications that do need to be responded to within a certain amount of time. And again, what this will look like might be specific to your business, but things like scheduling of shipments, where there is a time constraint in order to respond. And then again, as Bettina mentioned, you could have that idea of all communications only need to be addressed where they're urgent or emergencies, So those kinds of things would really be important. If you're going to have something like that, you need to define what an urgent communication is, what it's going to look like, what the expectation is if you're going to have that as the subject matter. So again, these are just some more ideas of ways you can split up what a blackout period looks like. And again, you don't want to include all of these in your policy because it could be a little onerous that way. Next slide. So part of developing and planning your policy is to look at the technology you have in your workplace and how it's being used. So you want to ask yourself, what kind of problems is the technology that our workplace uses, what kind of problems it creates. Once you know the kinds of problems it creates, can it be adjusted? For example, if you have a problem with people sending Slack messages late into the evening on weekends, maybe you want to look at turning off that messaging system or any other internal application for a certain time period. I know there's certain companies that have introduced turning off their servers at certain times altogether. Now that might not work for your workplace, but that's an extreme example. Another example has been where an employee goes on vacation and they receive an email. Some companies have gone as far as to send an automatic response to the sender saying this email will be deleted, and if it's really that important, to send it again when the individual returns from vacation. So these are just different examples of what companies have been doing across the globe on how to handle just this development of technology and the burden that comes along with always being reachable. So, you might want to update your policy as you have new technologies introduced into the workplace, or just make sure that the technology that you have, it makes sense with what your requirements are within your policy. Next slide. So there's a lot of things that email has been a burden for a lot of people, just given how easy it is to send off a quick email at 1 a.m. And you don't really think about when it reaches the other person, what it's going to entail. So there's a lot of different things you can do to utilize your email system if you're having issues like that. So a lot of email systems allow for distinct absence notifications, out of office messages. These out of office messages could be internal to your colleagues, or they could also be ones for external senders. So you want to consider whether employees should now have these constant out of office notifications. Do you want employees that are, say, administrative staff to have out of office notifications between certain hours of the day where they just are likely not reachable? If you're going to have something like that, what should these out of office notifications say? Should the one that's internal for colleagues look different than the one that's for external individuals who send emails? All of these same considerations go for voicemail as well, perhaps text message. So these are just the kinds of things to consider about these automatic notifications as one method to introduce in your disconnecting from work policies. Next slide.
Okay, well, that concludes the presentation on the strict legal requirements under the Ontario legislation. We're going to move into the latter half of our presentation where we will be introducing our colleagues from Europe. Before we do that, I did want to address the fact that I do see that we have close to 100 questions in the chat. We don't have time during this presentation to cover questions, unfortunately, because we're trying to give you as much content as we can. What we are going to do is take the questions, and within the next week or so, we're going to be issuing another recorded session that you don't have to attend. It's not going to be live, but we're going to address everyone's questions. And we will be sending out links to all of the registrants for this session so that you can, at your leisure, log into that pre-recorded presentation to see what types of questions other people had and how we address them. We do have to indicate to you that this is not intended to be individualized legal advice. So we'll be addressing sort of basic questions as opposed to questions unique to particular employment situations. Of course, please feel free to contact us to have those discussions individually. On that note, we're trying something new, and we know that everybody's having challenges developing these policies because we're getting lots of calls from clients. And we're receiving a lot of requests for help with policies. What we have developed is a checklist that will help you as employers to go through and figure out what are the things that we need to be thinking about as we develop our policy. And we have developed a template policy, a basic template policy, and we're offering that to individual employers at a cost of $1,000. And then if you purchase that checklist along with the template, the basic template policy, you'll also receive a $500 credit toward legal fees from any one of us in the employment group at Gowlings to help you tailor the policy then to your individual workplace. So please feel free to contact Hina or I if you'd like to have some help with the policy and take advantage of the checklist and the template policy, or reach out to any other employment lawyer that you deal with within Gowlings, or if you have a regular corporate lawyer or so on, reach out to them, they'll direct it to us. Okay, now I have the pleasure of introducing our speakers from Europe. And I will start first with Kevin Langford, who is a partner with the firm of Arthur Cox LLP. Kevin practices employment law in Ireland. Arthur Cox is located in Ireland. Kevin is the head of the employment group in Ireland. He provides advice to all different types of employers in various industries, from pharmaceutical, manufacturing, retail, cultural institutions, hospitals, schools, you name it. If it's out there, Kevin can provide advice there. Kevin is not only a solicitor, but he is a barrister, as we refer to them in the US, or a litigator, or in Europe, litigator typically in North America. He practices or appears before the Workplace Relations Commission, labor court, civil courts, dealing with the same types of issues that we have in Canada: human rights, discrimination, occupational stress, contractual disputes, union matters, that type of thing. Kevin also engages in workplace investigations, and he is involved in other organizations, health and safety groups, and he assists his firm with criminal prosecutions in the health and safety realm as well. So welcome, Kevin. Thank you very much for participating. Moving on then to Andre Pestana Nascimento. I really hope, Andre, that I did not butcher that. Andre practices in Portugal with the firm Uria Menendez. And Andre is a partner at that firm, again, in the employment and pensions group. His practice is very similar to those of ours in Canada. Again, he deals with employment law, employment litigation, collective bargaining, also privacy, pensions, and social security law, which is a little bit different than what we do here. Andre deals with restructures, downsizing procedures, and we have to remember that in Europe, those types of things are a little bit different than we have to deal with in Canada. There are councils and things like that that get involved, and so it's a little bit more complicated. Andre also helps on the employment side of things with mergers and acquisitions, which is a very important piece of any type of transaction. Finally is Stefano Biagioli. And again, Stefano, I really hope I got that right. He is a partner with Gianni and Origoni in Italy. Again, Stefano is an employment lawyer dealing with all aspects of labor matters, both contentious and pre-contentious. I love that, the way that you put that, Andre. I love the pre-contentious. And he assists with both Italian and foreign companies who carry on business in Italy. He has significant experience in the labor aspect of things as well, unions and industrial relations. And he also is involved and appears before courts. He graduated from Luigi Bocconi University, and he is a member of the Italian bar and speaks Italian and English. Thank you very much to our distinguished panelists for joining us. It's going to be very interesting hearing how things have progressed with the legislation in your various jurisdictions. One of the things that I want to note is that for Portugal, their legislation just came into effect in January. So it'll be interesting to hear from Andre how things have progressed there in the very early stages for those folks in Portugal. Okay, Kina, can you please just start off asking the first question while I am having technical difficulties myself and have to pull up our questions. So can you go ahead?
So the way I'm going to go about this is I'm going to ask each of our panelists the questions and the same question, and they can answer, based on their own experience in their jurisdiction. So starting with you, Stefano, what advice did you give your clients when they first started to develop their disconnecting from work policies, and how did your clients get started?
Okay, first of all, thank you very much for the introduction and for inviting us to take part in this webinar, which is covering a very important topic and, as we all know, also a real challenge in the future of the employment law, actually. In Italy, disconnection rights are strictly connected with the adoption of so-called flexible working models. And there are no policies governing only the right to be disconnected. In this respect, we have a specific law on flexible work issued in 2017, which has been recently integrated by a protocol issued by the government and social parties in December. There is also an emergency legislation that will expire so far at the end of June, which has permitted employers to unilaterally impose flexible working in companies, basically treated as an health and safety measure. That said, employers and employees must enter into an individual agreement which must touch the following matters. So this is our starting point with clients. Define the duration of the policy, define the tools and instruments used by the employee to render the working activity and to grant the disconnection, define the conducts of the employees that may trigger disciplinary measures, define the places where the working activity is not permitted, and lastly, specific training in matter of health and safety. As a conclusion, we can say that the right selection of technology and tools by the employer makes the difference in order to allow the disconnection rights of the employees. So this is an important step to consider in order to start.
Thank you. That makes a lot of sense. So Kevin, I'm going to ask you the same question. What advice did you give your clients when they first started to draft their policies, and how did your clients get started?
Good afternoon, everyone, or good morning, I guess, in Canada. And thanks very much for giving me the opportunity to join the webinar today. We have a code of practice in Ireland. It's not legislation as such, but it's a code that was introduced under legislation, and we're coming up on its first anniversary. It was introduced in April 2021. It essentially defines the right to disconnect, and it does so, or it effectively does so by reference to 3 rights of employees. The first is the right to not routinely perform work outside of your normal working hours. The second is the right not to be penalized for refusing to work outside of your normal working hours. And the third is a duty to respect another person's right to disconnect. So they are the 3 central pillars in the code. In terms of advising clients on drafting policies to deal with the right to disconnect, in one sense, we were helped by the fact that the code actually contains a sample policy, which is very useful, and it contains a number of template clauses that you might wish to include in the policy, including, dealing with such issues as the appropriateness of sending, or the content of what an out of office email message might look like, the appropriateness of arranging meetings at inconvenient times and ensuring that only those who are necessary to attend meetings are attending meetings, and so on. So that's all very useful content. I think just a final introductory point related to the issue of right to disconnect. We have the issue also of remote working. So there is draft legislation at the moment, which is about to be introduced, whereby employees can request the right to work remotely from their employer. So I think that is another related issue, which employers are dealing with at the moment, because obviously with the pandemic in the last 2 years, employees were working from home pretty much all the time, and that gave rise to right to disconnect issues. But it also now gives rise to the scenario where employees are looking to continue working from home in the future.
Thanks, Kevin. I wish our legislation had a little bit more guidance about what to include in a policy, but it just does not. And so, Andre, in Portugal, I know it's very recent, just this past January, that you've had this requirement. So can you tell us a little bit about how your clients got started?
Absolutely. Good afternoon, everyone. Thank you also to Gowling for inviting us for the webinar, and thank you everyone for connecting. Exactly. In Portugal, the law was just passed at the end of December. It entered into force in January this year. As in Canada, the law does not provide any guidance, and I will just read what the law says. The law says the employer shall refrain from contacting the employee during the resting periods, except in cases of force majeure. This is it. There's not any more guidance than this. So we are still in the early morning trying to understand exactly, fully understand the law. Apparently it applies to all employees. It applies to all the companies. More than a right to disconnect, it's a duty on the employer not to contact the employees. And that is an important difference, because if you just have a right to disconnect, which in my view we already had in Portugal, the employee is of course entitled not to pick up the phone, not to look at his email, but the employer could be able to try and contacting him. Now, with this obligation not to disturb any employee during resting periods, the matter is different. I saw one of the questions that was in the Q&A was if this applied to on-call employees. And I saw that was a question for Canada, but I would say that with this law that we have in Portugal, on-call employees should be left out, because if you are on call, technically you are not during your resting period. But again, there's not much guidance. So what we told our clients was that the law does not say that it's mandatory to have an internal policy. Although I must say that last year, the European Union has begun drafting right of disconnecting directive. So it's shortly, this will be mandatory across all European Union jurisdictions. So the policy for now is not mandatory, but I think that when speaking to clients, there were pretty much three alternatives: do nothing and rely on the employees' managers' common sense, probably not a very good idea. Do nothing or just not approve any policy and just provide some awareness sessions and training, probably not a good idea as well. You could go the whole way and immediately implement some hardware to block or prevent servers from getting emails, probably a little too harsh, in particular now where we have so many employees working flexible working arrangements, or, which is what we at the end of the day suggested, having a clear guideline explaining everyone what to do, what not to do, expectations, probably include some disclaimers at the end of the emails if you have a high number of employees working flexible arrangements, but for sure that the policy should be in place.
Okay, thank you very much. Although we're, an ocean apart, it sounds like there are a lot of similarities going on in each of your countries with the struggles that we're having with this policy as well. So Andre, I'm going to keep you on the hot spot or in the hot seat. When you've been talking to your clients, have they indicated to you whether or not in drafting their policies or thinking about it, are they consulting with their management teams or, just management, or are they consulting with employees, or is this just more of a, upper management is figuring this out on their own and they're going to implement things? What have you been seeing?
Our experience tells us that this is being decided at an upper level. So we are liaising with HR departments, legal departments, compliance departments. We don't see managers usually highly involved. Of course, if you are a company with employees representative structures, those should be consulted before the policy is actually approved. But if you don't have those structures with your company, employees are not usually heard before it is approved. And what we see is that this is decided by HR, legal, or compliance.
Okay. And I'm going to add a tack-on question to that. How do employees typically react to that type of thing? And how do you have any predictions as to how employees are going to react to this sort of mandated implementation of a policy, which I get usually happens, but with no consultation with business to determine, this is how this particular department functions or something. How do you think employees with your clients are going to react?
So far, we haven't received any negative feedback. I mean, the policy at the end of the day is to the benefit of everyone, particularly the employees. And so even if they have not been heard, probably the ones suffering more with this are the managers, because they are the ones who will need to be a little more careful before reaching out to their colleagues. But from a I would say general perspective, we haven't received any negative feedback due to the fact that they have not been involved in the design of the policy.
Okay, good stuff. All right, Kevin, same question for you then. What are you seeing in Ireland with respect to the development of the policies? Are your clients involving management or employees in the consultation process as the policy is being developed?
Yeah, so I guess the starting point in Ireland is that the Code of Practice does actually explicitly state that employers must engage proactively with employees and trade unions or other employee representatives in order to develop a right to disconnect policy. So strictly speaking, there is an obligation to do so. And in fact, what's interesting is that whereas a breach of the code is not an offence itself, any breach of the code is admissible as evidence in the context of any claim that might be brought by an employee arising from any breach of the code. So for those reasons, it is critical that an employer does engage with employee and union stakeholders and so on before introducing a code. That said, I think there has been quite a divergent level of engagement. It's like everything else, I guess. Some employers are very proactive and prepared and they do all of the engagement. Others react and do things in a hurry and maybe don't consult to the extent that they should.
Right. Okay. That's interesting. And do your clients complain at all that it's onerous for them to have to consult with management employees?
Not really. I mean, I think it's just more probably an issue of the, if I can call it the HR burden, because there are so many policies and procedures that have to be put in place these days that if you have to consult in relation to each one of them, it can incur a lot of management time and so on. But the other question you'd asked, I guess, is about the employee's reaction. So even if the employer doesn't consult with the employees or the unions, if the code is if the policy is drafted in accordance with the code, like all of the content really is in favor of the employee. And also one point to make is that the code specifically calls out the right of an employee to be able to bring a grievance if the code isn't complied with. So a grievance procedure needs to be built in the policy. A two-step procedure, informal and formal, if the code isn't being complied with. So it is a favorable policy for employees. Generally, it doesn't impose any major, obligations on employees.
Right.
More on the employer.
Okay. And just a reminder for those of us in Ontario, of course, under the Employment Standards Act, we too have employees have the right to bring a complaint to the Labor Board if employers aren't complying with the Employment Standards Act. And these policies, once again, if they provide a greater right or benefit, would be enforceable under the Employment Standards Act. Okay, Stefano, over to you then. Are you finding that your clients are engaging in a consultative process with employees and managers as they develop the policies? And is that working? Is it not?
In general, our law does not include information or consultation duties in charge of the companies. And in general, the flexible working models follow a top-down approach, especially for middle-sized companies. That said, the protocol that has been issued in last December has strongly encouraged the role of the social parties. And since flexible work, disconnection matters, deal with work-life balance, wellness of employees, and also health and safety matters, the adoption of information and consultation procedures, for instance, with the trade unions, could be seen in the next future as a good practice. In this respect, it will be important to understand the impacts of the European directive mentioned by André and the enforcement of the principles of the protocol that I've explained, since so far it is only a best practice. And what we can see in the next future, at least in Italy, is a trend to delegate the matter in terms of flexible work, not to the only to the negotiation employer-employee, but within a level of national collective bargaining. So this could be the next step that so far we haven't experienced, but very likely, according to those principles, the role of the collective bargaining will become more effective in introducing these models.
Okay, thank you very much.
Okay, so heading back to you, Andre, how do your clients deal with the different types of positions and duties and needs within the same workplace? I know you're probably thinking about this right now.
Exactly, because again, unlike what happens in other jurisdictions in Portugal, and the draft European Union directive goes also in the same line. In Portugal, this applies to all employees, not only to those employees who are using digital tools. So if you are working in a factory, you are entitled not to be disturbed, but if you are working and you are always connected with your laptop and your mobile phone, you are also entitled not to be disturbed, and your employer is obliged not to disturb you. So the law does not distinguish between different types of employees. I would say that the thing here is that if you are, for example, working flexible arrangement, if you are not bound by any specific working schedule, that means that technically when you leave the premises, if that's the case, or you don't have any particular set of working hours, which means that you can be disturbed because you are sort of on a permanent on-call basis. So for managers or for supervisors, it's easier to cope because the vast majority of them has this exemption from working schedule. Those can be actually contacted outside regular working hours. What's difficult is that the law just has a simple line, and it just says that if it's not force majeure event, you cannot reach out. So this, of course, needs to be a little tempered, I would say. But at the end of the day, you need to pay close attention, and to, as Bettina was saying previously, having a policy is not enough. You need to monitor that the policy is being complied with. Probably you're going to need to have some sort of alarms being raised when you see someone sending more than 10, 15 emails outside what's supposed to be regular working hours or at the weekends, having a conversation with that supervisor or manager, trying to understand if it was really urgent or not, to show at the end of the day before the labor authorities or even a court, if you get a harassment claim, that you did your best and you really try to monitor. But for now, we don't see a differentiation in the policy between different types of employees because everyone is covered by the rule.
Okay, what about you, Kevin? Is there any sort of differentiation in your legislation? And whether there is or not, what are the different types of, how are the employers dealing with different positions and duties in the workplace?
Yeah, so similar to what Andre was saying about Portugal, the code in Ireland applies to all employees, doesn't distinguish between roles. The core right under the code in Ireland is that employees are not expected to respond to work emails or messages outside of working hours or during vacation. I mean, that is the core right. But I guess it's like every code or every piece of legislation, there are always exceptions. And there are some exceptions in the code, and one of them is that except for occasional legitimate situations where it is necessary for employees to engage outside working hours. Now, obviously, that doesn't mean that employees should be doing it routinely every day, but there is that exception. There is also an exception whereby there are genuine emergency situations, which would necessitate an employee dealing with emails outside of working hours. I guess maybe just one other point, though, despite what I've just said there. I think the real issue here is regarding breach of working time legislation. If employees aren't disconnecting, that they end up habitually exceeding the maximum weekly working time limits in Ireland, which, similar to Europe, is 48 hours a week, with certain exceptions. But there is an exception in relation to managers or people who determine their own working time. So in other words, if someone is very senior in an organization and effectively is autonomous and determines their own working hours, then they are not covered by the restrictions that will otherwise apply to other employees in relation to weekly working time limits. So I guess maybe that does give some flexibility in terms of maybe differentiating senior managers from other employees in relation to the right to disconnect.
Okay. And then Stefano, I'm going to ask you the same question. How are your clients handling the different positions and needs within the same workplace?
Yes, we have the same difficulties that have been anticipated by Andre and Kevin, because there is no specific direction within the regulation that we have. So we usually ask clients to duly consider the different types of positions and the impacts on their operational needs. The flexible work with particular reference to disconnection rights presents some difficulties, especially in order to manage the directional employees, top managers, supervisors, that also under our law system are outside the scope of the working time. So the enforceability of the disconnection rights is very difficult to identify. And in this respect, the trend is just to make reference to the general necessity to respect daily and weekly rest periods without identifying a specific time frame for these categories of employees.
Thank you very much. Okay, so we've talked in responding to the last question from Hina, you all mentioned situations with emergencies, having to deal with emergencies. Andre, in Portugal, you mentioned force majeure situations. So how exactly do your clients deal with that? So I guess my question is, if do you just send out do the managers just send out an email saying urgent, SOS, emergency, that type of thing? How is it typically handled, or do your clients share with you how they manage those urgent types of situations where you've got a policy that says perhaps, okay, employees, during these hours, you don't have to respond to messages, but now there's an emergency. So there's this sort of push and pull between, okay, don't look at your phone, but you better look at your phone in case of an emergency. And sorry, I'll get to my question, but it reminds me of a commercial that was out a few years ago where it was for a cold remedy, and the employee woke up and looked at her email and had a message from her manager saying, please respond to this before you wake up. And it's sort of that situation. How does an employee know that they've got to respond to emergency if they're not supposed to be looking at their emails? Andre, I'm going to start with you.
I think that's of course a funny situation, but a real one, because what we are seeing in many right to disconnect policies, which are global level, is that there's a paragraph saying if you are receiving your email outside your regular working hours, you don't have to reply it. You don't even have to go through the whole message unless it's urgent. Well, to see if it's urgent, you need to be available to look at the message and actually read the message. What we are trying to understand, first of all, is what's a force majeure event, because that's the only exception we have in Portugal. I mean, force majeure only if there's a fire at the premise, if there's an earthquake, if there's a flooding. That doesn't make sense. The concept here needs to be a little broader, I would say. But again, there's no jurisprudence, no case law over it yet. What we are seeing and also recommending to our clients is, of course, if it's an urgent matter, urgent business matter, they should send an email. Always go for the less intrusive mean possible. Send an email, send a message, see if they reply. If they don't reply within a reasonable time frame, give them a call. And so that's how it's being done on a daily basis, basically.
Okay, thank you very much. Kevin, I'm going to ask the same question of you. Are the Irish a little bit smarter than the rest of us and figured out a way to not look at email but respond to emergencies?
No, I mean, there's no magic wand here. I mean, emergencies happen in every employment, and I suppose it's just really important to be able to provide for these situations as best you can in terms of, specifically calling out in the policy, for example, that there may be, emergency situations that arise from time to time where it is necessary for you to be contacted, and possibly also mentioning that in the contract of employment. I think also maybe where, there's a situation where maybe it is anticipated that, I don't know, there might be an urgent shipment of product or something out of hours, that insofar as you can possibly do this, maybe kind of try and maybe have an on-call system or rotating, or having a rota among staff, so that it's where possible you spread the load, so that one week someone might be dealing with an emergency, whereas the next week someone else might be on standby or on call to deal with that emergency situation. I think just the other part of it, though, I mean, there is an element clearly of common sense here, and as I mentioned earlier, I think the big impact of this in terms of where it all goes wrong is if it ends up that an employee is working routinely in excess of the maximum weekly working hours, because that's the mechanism whereby they can, or the route whereby they can actually bring a claim. So if you end up in a situation where, I don't know, for a period of a few days or a few weeks, someone is dealing with an emergency, whether they work in IT or whatever, and they end up working excessive working hours, make it up to them, make sure they get time off, compensatory time off, so that hopefully it all balances out in the long run, and they don't end up over an extended period of time routinely working excessive working hours.
That absolutely makes good sense. Common sense. It should prevail. Let's hope in most circumstances. Stefano, how about in Italy? What are the processes that your clients are putting in place to deal with these emergencies? Kevin had suggested perhaps establishing on-call rotating shifts. Do you see any more of that? Or your clients coming up with some great ways to handle it?
It is not included nothing generally with respect to emergency situations. So this kind of conducts are treated on a case-by-case basis. Considering one principle that we have that is not already put in practice. In our law system, the definition of flexible work implies the absence of the working time schedule and the autonomy of the employee in the performance of the activities. So in theory, in a pure model of flexible work, you should be capable also to manage a possible or potential emergency. Okay. However, this could create, of course, claims, difficulties, or discourage the adoption of this kind of system. What I have seen only in one case is a mitigant for the dealing of emergency, whereby a policy stated that for certain projects or in case of emergency, the employee would be entitled to a specific compensation or to additional flexible working days if the emergency has reduced, let me say, the percentage of the flexible activity. However, this is not frequent. This is not frequent. So the problem is existing and let me say remains. Considering also the definition of flexible work that we have.
Right, okay, so it sounds pretty similar to, any situation that we normally have under our legislative requirements. You've got hours of work restrictions, you don't want to take advantage of employees. If you have policies and you're going to have situations where there have to be exceptions, fine. Don't abuse it though, employer. And if you do get into situations where you're having to exercise the exceptions on a regular basis, make sure that your employees are being compensated and looked after. I mean, that all makes very good sense. So I'm going to move ahead because I want to make sure that we get in some of the key questions. We talked about, or Andre, you brought up this idea about the flexible employees who are on flex time. And that really, I mean, it was starting to be a trend, but because of COVID, we found that with people working at home, their work days just completely, were blown up in terms of when they could work, especially if they had little kids at home who they had to, school and then find time to do work. So the work day, it just kind of blew up and became no more in terms of regular working hours. And now I'm sure you're seeing in Europe as well as we're seeing, employees really like that flexibility and they now want to insist on it as a term of employment. So if you have all different types of employees who are engaging in flexible time, how are your clients dealing with that with these right to disconnect policies, and not just the right of the employee to have flex time and you can't email me, or I'm trying to put this right, because an employee is now on flex time. So let's say they're working at 10 o'clock at night. They've got an agreement with the employer that they're going to work at 10 o'clock at night, but now they're sending emails because that's their working time. And now they're violating the rights of other employees who don't have their schedule. Kevin, I'll start with you. Are you seeing that in Ireland, and how are your clients dealing with it?
Yeah, no, I think the most challenging set of combined set of circumstances probably are the employee who is in their job having to deal with different time zones.
Right, yeah.
And also maybe working from home. So particularly over the last 2 years in the pandemic, and it might be someone in Ireland, which is obviously in Europe, having to deal with, clients or work colleagues indeed, in related companies in, Eastern Standard Time in the US, and also maybe the other way, in Asia. So they're getting it from all directions. I mean, the code isn't prescriptive in terms of when an employee must disconnect. It's just to make sure that the employee does have the opportunity to disconnect and has the right to put their hand up and sort of object if they end up having to work too many hours. I mean, look, it is possible to offer solutions like flexible working time and so on. But I think the main thing is just to be able to ensure, and I know I've made this point a number of times today, that it's just monitoring to ensure that an employee doesn't end up working excessively, because it is possible for employees to work, legally to work within different time zones, provided that their working pattern doesn't stretch out so that they end up working more than 48 hours a week on a routine basis. And I suppose just related to that, and the code also does mention the whole issue of employee well-being and welfare and stress and all of those issues. So that just that employees do have, so not just maybe the right to take flexible working and so on, but also that there are clearly available mechanisms for employees, like employee assistance programs and so on, particularly for those who are working from home and dealing with different time zones, so that they know that there are places they can go if they need help or support, or help with mental health issues and so on that might arise.
Sorry, I had muted myself. Thank you, Kevin. And rest assured, everyone on the call, I did pass grade 10 geography. Kevin, I'm so sorry that I keep referring to Europe. I know Ireland is not part of Europe. Andre, over to you. So it's interesting because you had mentioned that in Portugal, if an employee has a flex work arrangement, then the right to disconnect does not apply to them. I think that's what you said. Correct me if I'm wrong. But how does that work with other employees then, if the flex worker, as I had indicated, is working at 10 o'clock at night and the other employees are subject to the right to disconnect? How are your clients handling that? And to Kevin's point with respect to time zones as well.
Absolutely. I think that's, of course, the most challenging issue that needs to be addressed. First of all, is sending an email where you are copying one of your coworkers, although you are not asking anything from them, is that a contact at all? First question. I would say that probably for the legislator, this is a contact, but I don't know if this goes to court, if that's how the courts will see it. because the employee is not, if he's during his resting period, he is not obliged to look at his laptop or at his mobile phone. And so he was not contacted in a way that disturbed his rest. So this is something which needs to be firstly understood if sending out emails is or not a contact. Assuming it is, and policies are trying to avoid employees sending massively emails outside regular working hours. What we are seeing is that companies are, many of them are having a disclaimer at the end of the emails where they are saying, I work flexible work arrangement, it suits my pattern. If you are receiving this email outside your regular working hours, you are not bound to reply, take any action in relation thereto. So this is a safeguard, of course, for the company. But again, if you are more vigilant or diligent and you are looking at your emails while you are resting, you had to read the whole email before actually going through the disclaimer. So one technical option that could be feasible is to mark in the email whether or not it's urgent. And when you look at the email, simply by looking at the subject matter of the email, you have a sort of a flag saying if you should look into it or not. So that, of course, at least reduces time spent going through the whole email. Disclaimers are used mostly by companies who have a lot of employees working flexible work arrangements, or when there are many employees from other companies in different time zones sending out emails, and due to the differences, of course, someone is going to get disturbed while they are resting. So disclaimers are now getting more and more popular, and I would say that it could work for these employees.
Yeah, I think that that's a great tip, actually, and one that I hope people on this webinar in the audience will take into consideration implementing in their workplaces. It's a good practical way, an easy way to deal with that situation. Stefano, any way that your clients are handling that flex dilemma and different time zones and things like that?
Yes, as you can understand, it's not easy, and this is the real challenge, because we must be frequent in understanding that the flexible work is a modality applying in all countries, and we should consider also the disconnection times for this reason. A possible solution could be, but it must be, let me say, tailored on a case-by-case basis to identify a general policy with the common working times, considering if it's possible the different timing. Let me say, you are required to work in all countries, for instance, in all Europe during this particular time frame. For instance, from 8 a.m. until 3 p.m. Apart from the situation or where you work, and to impose common schedule on when to organize meeting, on when to send in an email, or when to organize call, or inform the employees on the necessity to verify the status of anyone, because if the employees flex the disconnection status, you are not entitled to send an email. This is very, very difficult to put in place. I can understand, and because again, it implies a real change of the mindset. So this is a challenge. This is a real challenge.
Yeah, I can see how challenging it is, this flexible time and these different time zones. I really liked Andre's option of having the subject matter in the email so you can determine if it's urgent or not. What I'm wondering is, beyond something like that, have any of your clients implemented technological means to enforce the policy? So, you know, going as far as to shutting off access at certain times to certain applications, or even just tracking when employees are logging on or off. I'm going to start with Kevin.
Yeah, no, I mean, there's been some anecdotal examples of companies who have well-known companies who have done that, but in my experience, employers haven't generally gone that far in Ireland. So it's just, you know, I think the most that employers are the furthest employers are going in Ireland is really just instilling a culture of ensuring that only urgent emails are sent outside of working hours, but not going so far as to block emails or anything like that. You know, or to be able to prevent employees from accessing emails outside of working hours. Just one other, I suppose, thing that some employers have encouraged in my experience is that, you know, everyone works to different working patterns, as we know, and, you know, people are busy and some people might want to do some work at the weekend, and maybe on a Sunday they draft emails to their team with about different things, but it's just, you can put everything in draft and save it. Don't hit the send button until Monday morning, you know. So there are things like that that can be done, but I don't think, in my experience, employers have gone so far as to physically prevent employees from sending or receiving emails outside of working hours.
Yeah, that makes sense. And you can also schedule for when emails are being sent. I know some people are encouraging that. Andre, have you had any discussions with your clients about enforcing through technological means a disconnecting policy?
Not yet. I mean, there was a couple of years ago, one of Volkswagen, for example, in Germany, they experienced this, they blocked the servers after a given hour, but that's easier if you are working in a factory and you go home and probably, unless you're a manager, you don't actually need to be disturbed. For the financial sector, insurance, it's much more difficult. So we haven't been recommending to clients such harsh measure. We haven't seen anyone adopting those kind of technical matters. What sometimes could be suggested is, for example, as Kevin was pointing out, some people are okay connecting in the weekend to start to at least not to solve some pending issues. Probably you could have a pop-up showing up asking you, do you really need to copy these persons? It's weekend. Can this be sent tomorrow morning? Is it okay if you send the email now, although it will only be actually sent tomorrow? So these sort of warnings, they could be thought over and considered by companies, but actually we haven't yet seen our clients resorting to these technical measures yet, no.
Okay, it seems like the onus is really being placed on the employee to consider when they're sending out the emails, to be mindful of other people's work schedules. So far, no one's taking the, I could say, draconian measures of just cutting off access. That makes sense. What about you, Stefano? Anything with technology to enforce the disconnecting policy?
As said, the technology, in our experience, is the most important issue when adopting a flexible work model. So we have both the solutions, the hard approach, whereby it is the system that block or postpone the communication during the disconnection times, or a soft approach that is the most used, where the employee indicates the offline or disconnect status using an application. But again, the right to be disconnected will make sense if the technology selected by the employer will for the disconnection. And as Andrea said, you can imagine system with pop-ups, with messages explaining that if it's necessary or not, to flag if it's urgent or not. But I think that in this respect, there is a lot of work to do to have a proper technology, and this is a difficult choice, let me say, for employers also to select the right instrument and tools to implement smart working, flexible working models and disconnection rights. That's it.
Okay, thank you very much. And this next question is perhaps going to be a little bit harder for you to answer, Andre, because the legislation is so new in Portugal. And so, Stefano, I'll start with you. Have you seen, it was mentioned by, I think, a couple of you on the panel that this is going to result or need to be a cultural or a mindset change within the organization. Since this legislation has come out and employers have started implementing these policies, have you noticed or have clients talked about the fact that it is culturally changing, or are things still just sort of status quo despite the fact that these policies are in place and these requirements are in place?
Consider this, Bettina, according to a recent statistic in Italy, candidates seeking for flexible work modalities in companies are increased by 55% as of the beginning of the pandemic. So as of March 2020. Flexible work tools, systems deal with well-being of the employees, work-life balance matters, and together with the adoption of welfare plans, all these factors must be seen as a key factor for the success and for the future, in order to be appealing in the market and also to retain the talents within the company. So there is a huge demand about the adoption of flexible work modality. In general, we have experienced that companies will, after the emergency, will implement structural models having 40% of flexible work and 60% of work from the office, let me say, the ordinary way. This especially in the credit and financial sector. Then, of course, it depends on the activity of the company. For instance, insurance sector have a percentage of, at least in Italy, a percentage of flexible workers very consistent. And this will apply also after the pandemic outbreak, because companies have already structured policies and the agreement with the employees that is necessary from our perspective have been already signed and communicated also to the authorities. This is necessary only to trigger a coverage for accidents at work. Okay, so this is the situation, and we need to deal with attention and be ready to the change, because this is what the candidates are asking within our market.
Right. Okay. So, Kevin, I'll turn to you and I'll tweak the question a little bit, because Stefano, I think you raise a really great point. So this whether employers like it or not, the culture has, so it sounds like it's already changed externally or internally, because candidates are now demanding this type of right to disconnect and flexibility, which seems to go hand in hand, although it's sometimes paradoxical. Kevin, how are you seeing things in Ireland? And do you see, are there generational differences in how people are responding to this right to disconnect? Like, are the old fogies saying, you know, why aren't those young folks willing to answer emails after hours, or is there anything like that?
Yeah, no, sure. It's a very, very important issue here at the moment. I mean, since the code came in a year ago, and even before that, I think definitely there is, organizations are a lot more mindful of not disturbing people at their weekends and out of hours, and people are being a lot more respectful. And even clients contacting me if they have to outside of hours of the weekend, you'll notice that they're apologetic about having to do so. And when I started law many years ago, it was almost a badge of honor to be working at weekends and sending emails to clients and getting emails at all hours of the day and night. Those days have long gone. I mean, there is, like other countries on this call, I guess, talent is, there is a war for talent at the moment, which talent retention is just such a huge issue for employers. And that, combined with the fact that a lot of the staff surveys say that the younger generation, if I can use that term, yes, money is important and employee compensation is important, but work-life balance is the most important thing. And that's why employees often leave organizations. It's to get better work-life balance. So it really is a critical issue here at the moment.
Okay. Andre, I think we'll end off with you with the same question. What are the trends in Portugal right now? And I mean, the country has instituted the right to disconnect legislation. Are the employers already ready? Like, are they gung-ho about engaging this? Is it going to be culturally accepted within organizations? Do you have the same struggles for talent, that type of thing? And will this policy help retain talent?
Absolutely. If employers are ready, no, I would say that they are not ready. In particular, I would say that in Portugal, and probably Stefano feels the same, in Italy, Spain, Southern Europe, there's a cultural thing of working late, which does not necessarily mean working more. If probably you take 2 hours off to have a good lunch and you leave later in the night. So it's a cultural thing which is changing. The problem that we are seeing is that we have a sort of a generational challenge here, is that most of managers and supervisors are people who were born in the 70s, 80s. And they used to work long hours, and they were not so mindful of the work-life balance. And they are the ones who need to contact or not contact their team. And younger generations are much more mindful of work-life balance. That's something which, of course, clearly attracts them more than money, I would say. We see that a lot in law firms, for example. We're having difficulties trying to exactly understand what younger lawyers want to retain talented lawyers. And so I think the cultural change needs to be centered in managers. They need to understand that what was okay for them 10 years ago is no longer okay. As Kevin was pointing out, 10 or 15 years ago, we would be sending, even ourselves lawyers, we would be sending emails at 1 or 2 a.m., either because we had a busy day or because we worked flexible work arrangements and we preferred. And nowadays, probably we are going to think twice before sending an email to a client at 2 a.m. or 3 a.m. in the morning, because we are also mindful of the client's resting periods. So for sure that there has already been a cultural change, but this will not happen overnight. And it's a good thing that at least here since January, we have more than a right to disconnect. We have an obligation not to contact employees.
Oh, what a brilliant way to end off that last statement. That was great. Fabulous. Well, thank you so much, everyone who attended. But I'm just going to say a few remarks and then turn it over to Elisa if she's still on to wrap up. Andre, Stefano, Kevin, your advice and your experiences so far with the legislation that you have in your countries has been really invaluable for us. Thank you so much for taking the time out of your schedules to talk to us. And I think that it's probably shutdown time for you guys. So no more work, get off email. Thank you all very much again for participating. And once again, everybody who's been watching, thank you. Remember that we have a checklist template policy that we are offering. So reach out to us if you need help with your templates. And I'll turn it over to Elisa now to talk about the next session that's coming up.
Oh, thank you, Bettina. Thank you for that very informative session. The employers definitely have some work ahead of them to determine what disconnecting from work means to their organization. And I think the information we learned today has been very helpful. And I echo Bettina's comments. Special thanks to Andre, Kevin, and Stefano for joining us today. So our next webinar is on another hot topic, remote workplace. A lot of employers are moving to permanent remote work or some form of hybrid remote work post-pandemic, and there are some issues that do come up with that type of arrangement. So we will be reviewing legal risks, best practices when it comes to remote workplace. That will be on April 20th, and we do hope that everyone will be able to join us for that session. Again, thank you to our speakers for a wonderful session today, and I wish everyone a very good day.